Good evening, honorable members. I'm Sean Feeney from the Office of Legislative Counsel. I was going to just touch on the highlights of this bill and answer any questions with regard to the content of this bill to the best of my ability. The bill itself starts off by repealing what is the current uniform law on paternity, which is found at Rhode Island General Laws 15.8.1 through 15.8.28, and that's the first 10 pages of the bill. And then it adopts what is titled the Uniform Parentage Act of 2018. This is based on model legislation and also legislation that has been adopted in several other states. The Uniform Parentage Act was originally promulgated in 1973 and has been revised and updated in a major way, first in 2002 and then in 2017 there was a major revision. And that major revision emphasizes a couple of things that are really contemporary, important, and reflective of society today. Those issues address predominantly in this bill assisted reproduction, surrogacy. It creates a gender-neutral scheme with regard to what is surrogacy and parenting issues, and it ensures equal treatment for same-sex couples with related to these issues. The bill itself, I know it's approximately 50 pages long. Part of the reason it is in such depth is that it breaks down into several categories what are people we find today in society in parenting roles. There are obviously the birth and genetic parents, but also pursuant to this bill, there are acknowledged parents, adjudicated parents, intended parents, presumed parents, and de facto parents, and they're treated differently, and that's part of the reason this bill is so comprehensive. It's a balancing and a weighing of what are interests and an attempt to treat fairly what are not only the interests of the adults that are directly involved in the child's life, but also in these various circumstances attempts to always create a circumstance so the best interest of the child comes first. The bill itself provides that records and a number of different records related to what are proceedings and people in the various categories will be held in the Department of Health, and that will actually just be updated from really what is taking place currently under Rhode Island law. One of the provisions in this particular bill that would be a new enactment is a register for a claim of paternity. Now, I had mentioned, and I know there, at least someone had asked me a question about this, what's the difference between a claim of paternity, a registration by a man, and what would be an acknowledgment signed by a man for paternity. And there's, in the bill, to fully understand how they're treated differently, registering for paternity actually is, in essence, in its simplest terms, almost a notice provision that a father is saying, this is my child. And there are a number of factors that can play into with regard to how that's dealt with. That could be in a court proceeding for paternity used as an admission. But that's short of an acknowledgement, which is in essence the birth mother and the other parent acknowledging that they are the parents of this child, which is a much stronger, much higher level, and if not withdrawn pursuant to the provisions of the Act, or if not challenged and in court pursuant to the provisions of the Act ultimately becomes the same as an adjudication. The registration provisions are important because as a notice, frequently what would be subsequent hearings involving that child, there needs to be involvement either of what is the registered father or a certification that no one has registered in that role, and thus the proceedings can go forward. There again, it protects and is a balance with regard to what is the claimed or alleged father and what are issues related to what could be parentage of the child. There are very detailed provisions with regard to authorization, limitations, and authority for genetic testing, and they encompass about 5 pages of this bill. There are establishments of rights, responsibilities, and requirements for protection of what are claims of paternity with regard to assisted reproduction. And it sets up what is a record that provides protection for all the parties in what is an instance, as long as they follow the provisions of this bill, for those that are involved in an assisted reproduction childbirth. The bill also deals with surrogacy, and it does make a distinction between 2 types of surrogacy. And with respect to surrogacy, there is genetic surrogacy and gestational surrogacy. The genetic surrogacy is where the woman who carries the child actually donates the egg for the surrogacy, whereas the gestational surrogacy, both the egg and the sperm are from other donors than the woman who is carrying the child to term. And there are different rights, with regard to the woman, by way of illustration, who is genetically related to the child. She can actually, in essence, rescind what is a surrogacy agreement for up to 72 hours following the birth. Withdraw the consent to the surrogacy agreement for what is a limited period of time. And there again, the bill balances the rights and responsibilities and the best interests of the child with regard to the people that are actually involved with regard to the birth of child. There's a number of provisions in here that attempt to strike what is a balance, and there are some time limits, and some of which, by way of illustration, a party has 2 years under the provisions of this bill to challenge an acknowledgment. That is, they voluntarily signed an acknowledgment that was filed. It's an official record, and if circumstances change, that they, in good faith, come to believe that they are not the parent of a child, they can challenge that acknowledgment for up to 2 years. They can rescind an acknowledgment just by filing a rescission for up to 60 days after the acknowledgment. So if circumstances change and they want to challenge what is their statement of paternity, they have 60 days to do it pursuant to the Act. There's 2 years to challenge the parentage of a child born through what was a marriage of a couple. There again, this is a situation where this is gender neutral and in full recognition of the rights of people to engage in a same-sex marriage. So there are circumstances whereby that the couple, whoever they may be, if in essence, and it's specifically addressed here, there was some type of fraud or some type of instance in which they have a legitimate reason to challenge it, they have a period of time to do it, a reasonable period of time to do it, and then also after that period of time is transpired, it's in the best interest of the child that the things, the circumstances and the parentage that has been established, that it continue in force. Generally, just as an overview, that's the bill, unless someone has some specific questions.
Representative Corvée?
First of all, I think that with regard to the importance and detail of this bill, I think you did a very fine job in an overview.
Thank you, sir.
I'm going to ask some questions. I'm not a lawyer. Let me say right off the bat that the question I have in my mind and my concern right now has absolutely nothing to do with gay marriage, gay adoption, or anything to do with non-heterosexual couples or marriages. I'm going to wade into this because there was a bill I put in a while ago, and I'm not trying to digress, Chairman, but I want to know if it's included in here. I realize this seems to be a very all-inclusive bill. You're from Leg Counsel.
Yes, sir.
Are you familiar with child support laws, etc.?
That's not a predominant area of my practice. I practice law regularly, but that's...
Does this bill have any tangential implication with that?
Only from the perspective that parents who are responsible for child support will be responsible for child support. It's...
Okay, I think that's enough. I appreciate that. Let me try to pose the question. Again, I'm not going to be too eloquent, and I may trip over my own tongue.
I think you're very eloquent.
So, example given. Best way I can do this is young man, young woman, woman gets pregnant. Man does not think, young men, young woman, do not think that the child is he is the father of the child. Comes the birth, they're looking for a name, they put the name of the male on there. After this, and there are child support payments, let's say, involved with this. Again, I told you I'm not too eloquent. Down the road, man finds out that he is not the father. If my memory serves me correctly, and I had this conversation with Sharon Santilli a number of years ago, even though that individual, that male, finds out he is not the father, he is still responsible for the payments. There's something unfair in that. Now, I realize that the importance of the child is paramount, but at the same time, you talked about striking a balance. There's something not right about that. And I was wondering, since this is an all-encompassing bill, does that situation, is it addressed here? Because you used a couple of phrases that I think would relate to the situation with regard to parenting, registration, actual parents, etc.
Sure.
So I'm wondering, throughout the body of this bill, is there anything that would address my hypothetical situation in this bill? And I realize it's a heterosexual couple, but I'm wondering if the wording here would somehow apply to that.
Sure,
Because
certainly.
and again, let me state, I realize the importance of protecting the child, but also there has to be some equity somewhere.
Certainly, and I think the bill addresses that. It's how you weigh and balance it. The bill doesn't touch anywhere on child support, okay? It deals with parentage, and the child support is related to you being a parent.
Right.
Okay, so in our hypothetical, we have the male believes he's the father of the child. He signs, we'll assume, what is pursuant to the bill, an acknowledgment. The mother says he's the father too. She signs the acknowledgment. Now, under the terms of the bill, within 60 days, what he can do is he can say, oh, I found out I'm not, or I want to challenge it. He can rescind that acknowledgement. It's as, by a rescission, it's as if it never took place.
What happens after 60 days?
Well, that depends upon what takes place vis-a-vis the mother. The mother could say, oh, yes, you are, and she could start a paternity action.
But if they have a test that says he is not after the 60 days, and he finds out after the 60 days.
He's done.
He's done?
Yeah, well, if genetics excludes him as being the father,
After 60
he's not
days.
responsible for the 60 days. And he also has 2 years to, under the terms of the act, to challenge what is the acknowledgement. That is, he can't automatically rescind it, but he can go into court and say, I'm challenging this acknowledgement that, in essence, I'm not the father. And in those circumstances, within that 2-year period of time under 15-8.1-3.102, which is on page 15, if he prevails, then in essence, there's a judicial determination he's not the father. And that plays into what is the very specific circumstances of the genetic testing. Now, after that 2-year period of time, he acknowledged it. He said it's my child. Supposedly, I would assume he's involved in the child's life. What the judgment is it's grossly unfair to the child for 5, 7, 10, 15 years later, him to say, all of a sudden, that's not my child. He is the parent legally and for all legal purposes after that period of time.
After the 2 years.
Right. But that's if there's an acknowledgement. He said it was his. Now, if he doesn't say it's his, well, the mother says it's his, she still has to file what is a paternity action. She has to adjudicate it and prove that he's the father.
Thank you, and thank you, Madam Chair.
Thank you, Representative Corvée. Any other questions?